Yep, that's you.
All right, thank you. I was told it's being recorded and I had to use my phone, so that's why I was just song. The first thing I'd like to say before I get started is, Christian's already indicated, their graduate for their services and the international office. And I'd like to thank Leah and Cynthia for putting this on and bringing on all of work. Use the services that you have on campus. Use graduate career services. They will help you get a job. Use the international office if you have questions regarding your F1 status, OPT, CPT, J1 issues, extensions, timing. Use the resources you have here. The people who are here on campus are very knowledgeable about these issues, so use them. And you don't need to hire an immigration lawyer. If you do, you're getting ripped off to get advice on an F1 or J1 issue. Use the resources that you have on campus. I guess that's probably not the way to start off the presentation, but I just wanted to put that out there first to use those references. As a way of background, my name is Tom Mark, I'm an immigration attorney. I'm also a graduate of the University of Notre Dame undergraduate and law school. I was an F1 student at one point in time. A lot of people think Canada doesn't really count, but I was issued an I-20. I was stopped at the border and questioned, both in a vehicle and traveling by plane. I was interviewed for my green card, became a US citizen. So I took immigration law here at Notre Dame, so that's how I got into it. I've been practicing law, I can tell you, but for 25 years now, I've been coming here for probably about 20 years. And I will say the international office has really picked up its game. When I first started coming here, it was cold pizza. Now it smells like delicious Chinese food, which is a little distracting. But the purpose of me being here today is to give you some helpful information about immigration law, to provide you with information that can help you maybe with options for permanent residence, self-petitioning for a green card, knowing how the H-1B process works, knowing what options employers may have to petition on their behalf. And so again, the whole purpose of me being here is to provide as much information as possible. I will open it up to questions afterwards, and then if you have an individual question you don't feel comfortable sharing, I'll stay afterwards. I did already meet today with about 20 different people, and I'm very impressed with the CVs I saw. A lot of very, very highly qualified people. Now, I'm not sure who's running the slide.
I got it.
You could please advance me a chance. Thank you. This is an overview of the presentation today. It's just generally F1 status, J1 status, H1B, non-immigrant status, permanent residence. And it's just a general overview. Some people have a very good understanding of the immigration process. Some people don't. So I'll just give you kind of a Cliff Notes version of the overall process and then get into more detail. As far as F1, OPT, STEM extension, again, use the international office on campus for those types of questions. J1, you want to be aware of the 2-year home residence requirement, which I'll get into. H-1B, it's a good option for you if you have an employer willing to file an H-1B petition for you. If you're going to go work in industry, you need to be aware of the H-1B cap and the timing constraints associated with that. But dual intent means you can have a green card application pending, even an adjustment of status, and travel in and out of the country while that's pending. O1, extraordinary ability. File a lot of those petitions, and I guess give you a little background. I represent a number of universities all over the country, doctors, researchers, and we have a large group of people in my firm that we focus on that. And Zoom has been somewhat interesting because I used to give these presentations, fly around the country to do them, and now last year giving presentations to Oxford and Harvard and places like the Canadian Postdoctoral Association, just in our living room. So it's a different ball game here, but the good news for you is the resources are also available to you much more easily now than they were previously. O1, if you're subject to the 2-year rule, you can't get a waiver, it's a good option for you to buy time. Do it for a lot of foreign physicians who are subject to the 2-year rule. And so if you're a Fulbrighter, for example, and you can't get a waiver, an O1 may be a good option for an employer to file that on your behalf. Permanent residence, green card.
These are a couple of options, EB2 and NIW or EB1A extraordinary ability, where you can self-petition. You can petition on your own for a green card. You don't need an employer to file a petition on your behalf. Many people aren't aware of that, but if your credentials justify it, it may be an option for you as a PhD student or postdoc or research assistant. Updates. The good news is that the immigration system in general has become a little bit more friendly over the last few years. There was a 4-year period that it was very challenging. I will leave it at that. It became very challenging, as people are aware, with travel bans and public charge issues and things of that nature. And it has gotten much better. There is a premium processing that's available now for national interest waiver petitions that wasn't previously available. It's for now only available for cases that have been pending an extended period of time. But we're hoping that that phases in for all cases. In many other countries in the world, if you pay the government extra money, they call it bribery. Here we call it premium processing. You pay an extra $2,500 instead of 8 or 9 months to get a decision in 15 days. So, but that's how it works. Every month, the USCIS will update the list for what's available for premium processing. And again, those are the fees and the time. Sometimes, though, it's not worth the money to pay the premium processing, so we counsel our clients on that. I was an international student here in law school. I had 4 jobs when I was in law school. I know $2,500 is a lot of money, especially for people who are watching their budget as a PhD student or postdoc. So we try to counsel our clients to only pay it if you have to. Also, some good news is with the STEM initiatives. There have been additional fields that have been added. So for STEM OPT, there are more options. And it's also helped for national interest waiver petitions. The national interest waiver category has become a lot more flexible fairly recently. And the government is open to more arguments. I'll get into that later. We have a website that shows different types of cases, but we've been getting cases approved that actually some people with no citations, if you can show that their work is extremely compelling in the eyes of the government. And there are people, for example, who work on clinical trials. They don't necessarily publish, they're not cited, but it's clear that their work is in national interest. EB1B, there's been some, EB1B is outstanding professional researcher, so that has to be filed by the employer on your behalf. We file a lot of those on behalf of institutions of higher education that are filing for tenure track faculty members, for example, primarily who may be born in India, who have a long waiting period of up to 10 years for the EB2 process. But there again, it's the employer has to file it, and you have to meet the criteria. There's a number of criteria that are possible. You have to meet at least 2, and then go through this kind of final merits determination. But the good thing is that the government now is looking at if you serving in a leading or critical role. Before it had to be for an institution, now it can be for a department, for example. So instead of, it's a hard argument to make to say that what you're doing is a leading or you're serving in a leading or critical role for the University of Notre Dame, but it's an easier argument to make that you're serving in a leading or critical role for your department. The other thing is published material includes readings beyond print. The immigration system is still a little bit archaic in terms of USCIS and their inability to digitize everything. Before you have to show everything as far as a print article and things of that. They'll now accept articles online, which is what everybody uses. They finally accepted that. That's become helpful in terms of providing evidence to USCIS to prove the case, because USCIS officers want you to prove through evidence, supporting documentation, all the statements that you can't just make a statement about certain things without providing supporting documentation and evidence to prove that point. again, updates, although the 4 years before were challenging, then COVID came along and added some additional challenges, as we're all very well aware of. And so some of the delays before may have been caused by the administration. Then we had delays caused by COVID, understaffing at the Department of State, consulates or embassies being shutting down. So that's created issues. And it's always been challenging for some countries to get visas, for individuals from most countries to get visas. That's become even more challenging in some cases. And again, if you need to travel, if you're on an F or a J, you probably want to talk to the international office before you leave the country to make sure that they think that it's okay for you to leave, because it's a lot easier for them to cancel you here in the United States than if you're stuck in another country, because that becomes more challenging. I actually had a university hire me to sue the federal government for mandamus action. Yeah, I did. And we were successful. That it was an H-1B. Somebody worked for a university. They were very well qualified. They'd been stuck in administrative processing and they weren't getting anywhere. So we filed a lawsuit in federal court and they came in and they're here working. But unfortunately, sometimes you have to get to that point. We try not to, but sometimes it gets to that point when the government just doesn't do anything. Processing times also have improved significantly. So for national interest waivers, for example, the processing times were stagnant for a long time. At older cases, some of them were taking over a year, which is why USCIS implemented premium processing for cases outside a year. Newer cases, we are seeing some cases get approved within 3 months. That's not common, but there are some cases. But as you've indicated, see here, many within 6 months, 8 months now, which is good news because they're getting processed far more quickly. OPT, I'm not really going to touch on this too much because the international office covers all of these. The bottom line is you want to be very careful about making sure you minimize your time that you're unemployed and have an appointment with the international office in terms of your timing for applying for OPT. And again, the good news is that there are more STEM fields now, so you can maybe have up to 3 years in OPT after you graduate, which is a great opportunity for you to find an employer, for example, that may be willing to sponsor you. The one thing for the STEM, you want to be careful with, again, with the international office. If you're going to work for an employer, you want to find out at some point in time if they're enrolled in E-Verify, because if you're there on your first year, it could be problematic for you to stay there if they're not enrolled in E-Verify. And again, unemployment should be minimized. J, the big issue with J is the 2-year home residence requirement. So you need to be careful. I met with some people today. I've talked to probably a few thousand people over the last couple of decades who are on J, and there's a 2-year issue. The J is a good option for universities to bring people in as postdocs, for example, but oftentimes there's a 2-year home residence requirement. And if you're subject to that 2-year home residence requirement, you either need to go home for 2 years, which most people don't want to do, or you need to get a waiver. And there are different types of waivers. If you're subject because of the skills list, then you can get a no objection statement from your home country. If it's because you got government funding, then you need to get an interested government agency waiver. If you have a Fulbright funding, then there's almost no chance you're going to get a waiver. And I did be at the strong request of a provost, get a waiver for somebody who had Fulbright funding, but they had a very compelling case. It was a professor. She was working on some very compelling research. She was from Africa and had a very compelling human story, and we were able to get the waiver. But generally, if you have a Fulbright and you're trying to get a waiver, it's highly unlikely, and that's where an O1 may be an option for you to come in. We've done that for one person at a State University probably got 10 years in a row for a no one because they were a Fulbrighter and there's no way they're getting a waiver. The other thing is, which doesn't really apply, but for foreign medical graduates, they're almost always going to be subject to the 2-year rule. Timing, sorry, you can just go back on. Timing is important, and I had this conversation a number of times today for the J1, that you want to be careful, and again, you want to talk to the international office about this, but once you've applied for a waiver, it may be challenging for you to get any extension, or you may not be able to get an extension of your J. So if you are applying for the waiver of the 2-year rule, you're going to also apply for a green card. If you're going to apply for the waiver, you want to do it likely right after you apply for your extension. So it gives you as much time as you possibly can have to get your employment authorization document, your temporary work card that you can file for along with the green card. So just as a kind of summary, there's the I-140 immigrant petition for alien worker. You can file that for the national interest waiver or adjustment of status. There's the I-485, which is your adjustment of status, where you file to adjust your status from a non-immigrant to a permanent resident. You can file those both at the same time. Generally, if you weren't born in India or China under EB2, but you want to be careful about filing those documents in terms of timing with your J1 extension. So you don't foreclose yourself from getting an extension if you're getting close to the end, or making sure that you have your work card so that you can keep working with authorization before your status ends. H-1B dual intent, as I mentioned earlier, that's very favorable for non-immigrant status. Most Fs, Js have non-immigrant intent, generally, so that if you go out of the country and you apply for a visa and you've already started the green card process, it can be difficult to get a visa if you're in F or J status. If you have an H-1B, then it's no problem to get that visa and come in, even if you have a pending I-485 indefinite status application. H-1B for a specialty occupation, anybody in here is not going to have an issue in terms of your education. Sometimes it has to do more with the employer and the job. If you're going to work for a private company, if you're going to work for a large private company, I know some of the people I met with today are looking at jobs in big pharma and things like that. They're going to have a team of people who handle those things. If you're going to go work for a startup company, maybe that's funded by VC money or startup grants, or things like that. That's a little bit more challenging because it might be a very small company. So I've worked with a lot of companies, research park here, other research parks, where you have to be somewhat knowledgeable about the process because the job title, the job duties, and the minimum requirements are important to try and increase the probability of success that an H-1B gets approved. The H is employer specific. You can only work for the employer that filed the H-1B petition on your behalf. It's location specific. You can only work in the location for which the H-1B was approved. So if you're working for a company here in South Bend and you get transferred to San Francisco, then the company would need to file an amended H-1B because the amount that they need to pay somebody here is usually considerably less than what they need to pay somebody in San Francisco because of wage requirements. And it's job specific. If you're working here as a research scientist for a company, and then they want to transfer you into a managerial position, the company would need to file an amended H-1B so you could work in that managerial position. The company has to pay at or above the prevailing wage, which is the wage set forth by the Department of Labor in a specific area, and the actual wage, which is paid to other people in a similar job. So it's just something to be aware of, because if the small company isn't careful with the job duty and descriptions, the prevailing wage that is assigned by the Department of Labor will be more than they can pay you, and there will be no H-1B petition. There's a cap. So if you're going to go work for a private company, then you need to be very wary of the H-1B cap. There are far more people who apply every year for private companies than there are H's available. There's about 200,000 or 300,000, usually closer to 300,000 recently apply, and there's about 65,000 that are available. There's 65,000 for people with undergrad, and additional 20 if you've earned a master's or higher from U.S. institution of higher education. So if you're wanting to go work for a private company, you want to make sure you have a backup plan. There are some people that we've dealt with, they get approved year one. There are some people who have taken 3 tries to finally get selected, and that's where you can use your 3 years of OPT to keep employed with that company for an extended period of time to give you more chances to apply under the H-1B lottery system. There's a registration that starts in March, then there's a selection in April. You file the petition. If it's approved, it would start October 1st. So that's another thing, is that the H-1B would start October 1st, which is the beginning of USCIS fiscal year. If you are approved for a company and they file an extension, usually the H is good for 3 years. If they file to extend for another 3, that extension is not subject to the cap, could be filed at any time. If you're changing employers, you work at company A, go to work for company B, the H-1B petition filed by company B is not subject to the cap, can be filed at any time. And if it's amendment, you're working for the company as a research scientist and they want to put you in a managerial position, that H-1B petition can also be filed at any time. It doesn't have to be filed April 1st for an October 1 start date. Here are some other options that are maybe available to some people, depending on where you were born. The TN, so if you want to go work for a private company, the H-1B cap is an issue, or the prevailing wage is an issue. There's a TN for Canadian and Mexican citizens. There's a schedule, and used to be 1603 D1 to the North American Free Trade Agreement. Now it's the US Mexico Canada Agreement, but there's a list of occupations that are in there that are covered, and it's a lot of employers like the TN because it's faster, cheaper, and easier for the employer. There's no prevailing wage component. If you can't find the job you want here in the United States, and you're going to go work for a large multinational corporation, you could go work abroad and then get transferred in on an L1 if you go work abroad for a year. O1, extraordinary ability. Because of the H-1B cap, we've been filing a lot of these lately for employers on behalf of PhD students, postdocs who have good CV with quite a few publications, citations, service as a reviewer, because there's no H-1B cap issue, and they can be filed at any time during the year. So the O1s become a very good option for employers to file on behalf of highly qualified scientists and researchers. H-1B1, similar to the H for people who are born in Chile or Singapore, and E3 for Australian citizens, again, similar to the H-1B, but both the H-1B1 and E3 have no caps, so they can be filed at any time. Green cards, family-based. If you marry a U.S. citizen, for example, there's no waiting period, you can file. If you are a citizen, you can file for your parents, there's no waiting time. Closer the family relationship, the shorter the period of wait to get your green card is kind of a brief way to explain it. For the green card, most people have to go through what's called labor certification, where the employer advertises, has to show there's no qualified U.S. workers for the position. If it's a non-teaching position, if it's a teaching position with usually a tenure track, then the employer just has to show that you are the most qualified applicant for the position, which is a lower standard. And there just has to be one national ad. It has to be filed within 18 months of the date of your offer letter. So if you go to work for if you're looking to work in an academic position, as soon as you get your first assistant professor job, you probably want to talk to the university about starting your green card application, because there are things that you need to get for labor certification, one of which is a prevailing wage, and those are taking 7 or 8 months now. So you got to get started right away on the green card process. The universities that we work with, we used to say, okay, wait, or maybe wait 6 months to see if they're a good fit. They like it there, you like them, it's a good fit, but we can't do that anymore. We have to start it right away. But most have to go through labor certification. After labor certification, there's the I-140 filed with USCIS to show that the employer has the money to pay the individual, that the employer or that the individual has the credentials and that the employer has the money to pay. And then there's the adjustment of status. However, for most of the people in this room, you probably don't ever have to go through labor certification if you have the requisite credentials. If you're in a tenure track faculty job, labor certification is not too bad. If you're in an industry job, labor certification is quite cumbersome. Again, because you have to have 2 Sunday ads, 3 other sources of advertising, has to be published in the state workforce website, and the employer has to show there's no other qualified U.S. workers for the job, which is sometimes a tough standard to prove. Self-petitioning, I won't touch on the last one because most people don't have that much money. And it takes forever. So I won't really touch on the last one. I have filed several of those applications, but it doesn't apply to most people. So I'll focus on A and B. The national interest waiver, you can self-petition. Generally, if you're a PhD student and you have a strong CV or a postdoc, you may have a good case. I'll talk about that briefly. Extraordinary ability, generally, we don't file extraordinary ability unless somebody is from a country, specifically India, where they have like a 10-year waiting period under EB2. And because the criteria they're scrutinized quite closely by USCIS, and there's something that's called a final merits determination. So even if USCIS, the officer finds, okay, yes, you've met at least 3 of the criteria, then the officer can state in his or her subjective opinion, yes, you've met at least 3 of the criteria, but we don't think that you're one of the very best in the world, so we're not going to prove your case. And that's where sometimes it's challenging because it's hard to predict what officer you're going to get, how that officer is going to adjudicate your case, and whether or not they're going to approve it. And there are some cases we've had individuals who have less than 100 citations, around 100 citations, just regular service as a reviewer, and they've had good but not great publications, been approved under EB1A. There have been other people that we've had. Just had one recently, works for a Nobel Prize winner, got a letter from the Nobel Prize winner. I don't think the officer even read the petition and said, well, we're not sure if this work is of major significance, when the letter from the Nobel Prize winner said specifically the work was of major significance. So those are the things that are hard to predict, is which officer gets your case, just like it's hard to predict when you're coming for a visa interview, who you're going to get. Are they going to sit down and say denied, or are they going to approve you? You don't know until you sit down. Or when you're walking in and there are people behind the plexiglass window, what kind of mood are they in? Are they going to say, welcome to the United States, or we'd like you to go into this room over here? It's kind of the same thing when you're filing petitions. The only thing that's almost worse about it is that these people are nameless and faceless. They have officer numbers, and there's some officer numbers I know that aren't good if you get assigned to that officer. Most are good. No, most are good, but there's some that are a challenge. Next slide. So again, one of the great things about the national interest waiver is that you skip labor certification. You don't need an employer, you can petition on your own. We have a website there, nationalinterestwaivers.com. You can go and look on it. We have different cases that we filed, approval notices that have been redacted to see how long it's taking, summaries of different cases so you can compare your situation to some of the cases that we have there. It says what the fees are and the costs and everything. So that just gives you you can educate yourself on that process. these are the criteria. So the criteria, again, they're set up on the website, but your work has to have both substantial merit and be in national importance. So is your work in the national interest of the United States? Usually that's not an issue unless your work is somewhat regional or very regional. But a lot of people work in science. There's an argument that can be made that it's national or international. Are you well positioned to advance the endeavor? Are your credentials such to justify approval by USCIS? There again, they'll look at your CV, they'll look at your publications, citations. If you have a patent, maybe if that your work has shown that VC is interested in investing in it, or industry is interested in it, or you can show that you worked in clinical trials and your work was very important to going through to make sure that a vaccine got rolled out quickly. Those are different things, but it has to do primarily with your credentials. Now, on balance, would it be beneficial to the United States to waive the labor certification requirements? Here, is your work somewhat unique? Is what you do somewhat unique, or is it something where the employer should just advertise for the job and have to prove there are no qualified U.S. workers for it? So there, you have to kind of make the argument. That's where we make arguments about, well, it would be a waste of time for an employer to advertise for this job for somebody who has a PhD in chemistry and they're working on very highly technical research. You're not going to find somebody by advertising in the South Bend Tribune for 2 Sunday ads, right? I know people laugh, but that's you. Yeah, bureaucracy can be challenging. I'll leave it. I'll leave it at that. But that's part of the argument that has to be made. You have to convince a USCIS officer. And I work with my brother too, who's also an immigration attorney, went through it, and we have some really interesting conversations about USCIS officers and how they adjudicate cases. But you have to prove everything to the officer to make sure that the case is approved. Am I qualified? If you want, there's no cost or anything, us to review your CV and Google Scholar profile. You can email it to Stacy@dunlaw.com. She's immigration practice manager, worked with me for over a decade, worked at Caterpillar for 12 years doing their immigration. So she's been in for over 20 years also. But I'll be the one to go through and review it, or my brother or another immigration attorney. There's actually an immigration attorney that we work with who at one point in time was the director of the international office here many years ago, and he was a law school classmate of mine. Can you apply directly from J1 or F1 OPT? Yes, you can. You can apply directly. Whether you should depends on the timing, whether it makes sense, whether you need to file for your OPT STEM extension or your J, if you need to get an extension for your J, you need the 2-year rule. Can you? Yes, you can. Should you? It depends on your qualifications and the timing. Is it necessary to be, these are some of the questions we see. Is it necessary to be first author? No, it's not. I got that question several times today. And you don't have to be first author. Obviously it helps, but you don't have to be. And I had one meeting today where it was interesting, where somebody was really focused on being the first author, and that's actually holding them back a little bit because they don't have as many publications, so they don't have a recent publication on their CV, and it looks good to have recent publications on your CV before you apply. And so that's one of the things I see sometimes, is that if somebody hasn't had a publication for a couple of years, I'll maybe say, well, let's wait till your new publication comes out before you file because it looks better on your CV. How many citations do you need? Many years ago, there was the U.S. Department of Labor, which was called the New York Department of Transportation was the case. And now there's a case called Matter of Danisar, which is the seminal case for national interest waiver petitions. And it's made it way more flexible, so you don't actually have to have any citations now. We've got several cases approved in the last couple of weeks where people had 0 citations. But again, it depends on what you're doing and how compelling the argument can be made for your case. If you're a researcher, then citations are clearly going to be helpful for your case, but you don't have to have any. And I'm very cautious by nature. I'm cautious with the cases that I accept. I'm cautious with people's future and people's money, because I know how important the application is. And I say no to way more people that I say yes to in terms of talking to them and accepting their case. But there are many times where candidly I'm shocked. Maybe I shouldn't be, but where there's people who have no other options and they've insisted that I take their case because to make the most compelling case possible. And one always sticks out is that there was a person who worked at a community college, had done some research, had some citations, running out of time, married, 2 children, drove a long way to my office. I'd already told him 4 times no over the phone. He drove to my office with his kids, said, look, I want you to do this. I've done my research. I want it to be you to do this because I know you care, and you told me no 4 times. And I said, okay, I will do it, and put in bold letters, your case is likely to be denied. You know, it got approved, no RFP, and they got their green cards. And so sometimes those things happen, but I try to be very upfront. There's somebody I met with today, called me a year ago. I told them no, I didn't think you're qualified yet. And they came back again today, and now they're very well qualified because they've been working incredibly hard, obviously, over the last year to boost their CV, have their citations. So somebody can go from being unqualified to qualified relatively quickly, depending on what happens with their CV. Is a job offer required? No, it's not required, but it helps. It helps to show that if you have a job offer that you're going to continue to do work in your field of expertise. So it's not required. We file petitions, NIW petitions, for some people who are outside the United States, and they come in with their green card because they have a strong CV. We do it all the time, but it becomes a little bit more challenging. So you don't have to have one, but it's definitely helpful. And we file them for PhD students who are very well qualified. Sometimes they get their green card before they even graduate. That helps the PhD student with the job offer, or I'm sorry, with the job interview process. Because if you're going into interviews and you have a green card, it's going to help you, whether it's grants, it's going to help you with security clearance, it's going to help you with transfers or anything else. So obviously having a green card makes you a free agent and opens up a lot of options for you. Letters of support, dependent versus independent. Normally we file 4 letters of recommendation or letters of support. We try to split it up, a couple of dependent and a couple of independent. Independent being people who you've never worked with, you've never been a co-author with, who aren't tied to your CV in any way. Dependent are people maybe it's your PhD advisor or your current boss, or somebody you worked with at a different institution, or somebody who you have worked with. Sometimes people say, well, how can I get an independent? You may want to talk to your advisor. They might know somebody's willing to sign a letter, or you might want to look at people who've cited your work. Extraordinary ability, EB1A. I won't touch on this too. You have to meet at least 3 of the criteria. Again, you don't need employer sponsorship. It's a far higher standard, but if you're not in research, it's something that may be an option for you if you can prove you're one of the best in the world at what you do. And we do get some approved for postdocs, EB1As. That's a few in the last week. And again, sometimes we're surprised. People are persistent. They want us to file, and they get approved. But we're very upfront about it. Your chances, whether they're good or they're not good. And the issue with the EB1A is if you weren't born in China or India, and if you're born in China, the NIW is still a good option because it's only about a 3-year wait right now. So if you're in a PhD program, you get the NIW priority date. You'll probably have the approval by the time you graduate, and definitely by the time that your OPT expires, and then you can file your adjustment status. So for Chinese citizens, EB2 NIW is still a good option. And for Indians, sometimes Indians want to file under EB1A, so they want to wait to get their credentials up. But the thing about filing for the EB1A, I tell people, a lot of people say, well, I want to file under, I want to file under EB1A, I want to file under extraordinary ability. And I'll often joke with them and say, they're not handing out platinum green cards. You know, like, if you just because you got an extraordinary ability approval doesn't mean you get an extra special gold green card and you go to the front of the line, you don't have to wait and you can board ahead of everybody else. So file under the category that gives you the highest probability of success, that is the highest probability of success, is probably the least expensive option for you. Don't file under category that's going to reduce your chances of success. The one thing that EB1A does have is premium processing, so it's 15 days, but whether that makes sense is a personal decision. These are the criteria. I won't get into it in too much detail, but generally for most researchers, it's, again, they're going to look at the quality of your publications, they're going to look at your citations, service as a reviewer, going to look at whether you your work is of major significance. So reviewing is judging the work of others. Review work in and of itself, usually for an EB1A, is not that much unless you've done extensive review work. They're looking to see, have you been an editor? Have you been the chair of an international conference or a program committee? Things of that nature. They're looking at higher level review work for an EB1A. Here too, if the work that you've done is in a publication that has a high impact factor, you published in Nature or Nature Communications or Science, and those things can be showcased for an EB1A. Adjustment of status is the last stage in the green card process. This is where you file to adjust your status from a non-immigrant FJ H1B to a permanent resident or green card holder. In the last 4 years, everybody had to be interviewed. So we had tenured professors going in for interviews. That's changed now. So the good news is a lot of employment-based cases now, you don't have to go in for an interview. If it's an NIW or EB1A case, you don't have to go in for an interview, which has made the process much better for a lot of individuals, because the interview process for several years was a daunting process for many people. I-45 is where they look at your background. I-140 is where they look at your credentials. I-45, they do a background check. You get fingerprinted, photographed. They look at what memberships you had. There's some memberships that are looked at terrorist organizations. They look at, and one thing you want to be careful when you're traveling, social media. If you're traveling and applying for a visa, you're coming across, they can sometimes look at your phone, see what you're posting. That was more of a problem over the past 4 years, but still be careful about what you're posting. But they'll look at groups, organizations that you're a part of. They'll look at whether you can afford to support yourself, what they call public charge. That's become less of an issue now too over the last 4 years, which is helpful. So the good news, and it's nice to report good news for immigration for the first time in a long time, is that things are getting much better. The government's being far more open-minded. Cases are getting approved more quickly now that COVID's subdued. So things are getting much better, and cases are getting approved much more quickly with less stress and anxiety for the people who are applying. And there again is the website if you want to take a look at some of the cases and things, and happy to answer any questions that you may have at this time. Any questions? Yes.
Yeah, you spoke about how it's difficult for startups to get H1B sponsored from startups. So I was asking about whether internationals can themselves start a new company, and if that is not, I believe it might have many